Hello, my name is Terry Hedden. Welcome to today's webinar. Today we're going to take a little different slant. We often talk about marketing and sales growth, but today's topic is a little bit different. We're going to talk about security, stability, making sure you don't make any mistakes that get you in trouble. We've brought on one of the most talented employment law attorneys in the United States. His name is Phillip Russel. He is an attorney and shareholder at Olgetree Deakins. He's going to cover a lot of things that we need to be aware of and be cognizant of, and basically share with you information about the rules and regulations that are out there, especially those related to coronavirus, and how you can avoid any sort of legal consequences as a result of what you're doing or not doing out there in the market. He is a board certified lawyer who represents businesses only, so he is on the defensive end usually of employment law related things. So he's going to help us ensure we don't get in trouble with OSHA. He's going to help us ensure we don't get in trouble with wage and hour laws. He's the kind of guy that is incredibly powerful to have on your side during times like that. During the COVID pandemic crisis, he's been advising technology businesses of all shapes and sizes on a wide range of novel workspace legal issues, such as teleworking, social distancing, safety, reductions in force, furloughs, and paid sick leave due to the extended FMLA leave in the Families First Coronavirus Response Act. He's also advising employers on how to comply with numerous and conflicting state and local government stay-at-home and business closure orders. His guidance helps businesses protect the safety and health of their employees and implement strategies to minimize legal risks so they can be ready to thrive when the crisis ends. He is a shareholder and a global labor and employment law attorney from Olgetree Deakins. With that, Phil, we'll turn it over to you.
Thank you, Terry. Good afternoon, everybody. Yeah, we are barely afternoon on the East Coast. Happy to be with everyone. And as Terry said, lots going on. So we're going to cover a lot of material today. We're going to talk about issues like workplace safety, the new paid leaves that are part of the FFCRA, the Family First Coronavirus Response Act. We're going to talk about leaves, furloughs, and other issues as well, some other cost-saving ideas. We're going to cover a lot in 90 minutes. I'm going to encourage everyone to ask questions as we go by using the question box. I'm going to keep an eye on those questions as we go and try to address those questions during the subject matter. So in those three big buckets of safety, paid leaves, and then furloughs, I'm going to talk about that. In the safety area, one of the things I'm going to also discuss is we're going to drill down a little bit further on teleworking, because I think that's something that's important to technology firms in our industry, and try and be as industry specific as I can. But please do ask questions as we go. I'm not going to make you wait until the end. If it's something that is pertinent to the subject I'm discussing at the moment, I'll be happy to take those issues. As Terry said, I'm an employment lawyer. I represent businesses only. I don't represent employees, nor does anyone in my firm. We're a global labor and employment firm, and all we do is represent the employer. So if you are here for the employee side, you're in the wrong webinar. I'm sure my friends on the plaintiffs bar are probably doing their own. Maybe you should find one of those. But I am going to be talking today to businesses, to business owners, business executives, business managers, and about really these novel legal issues that have come up. My firm, Olgetree Deakins, I'm an equity shareholder in the firm in the Tampa office, but I've got a national practice that I do work directly for clients around the country. But we also have not even a network. These are our own lawyers, 900 around 53 offices in the US and some international offices as well. These are not affiliates or associates or franchised operations. That really is our firm. We're, I think, the second or third largest employment-focused firm. We're a boutique in that all we do is employment and labor law, but we are not small by any stretch. I've had the pleasure of being with Olgetree now for about 10 years in a wide range of clients, from mom and pop shops all the way up to big multinationals, and they all have a lot of the same issues that we deal with. So what we're going to cover today, those three main areas: teleworking, legal issues, and some workplace safety to go along with it. We'll talk about the paid sick leaves that come out of the FFCRA, and then I'm going to talk about some cost-saving measures like furloughs, reduced schedules, and others. I'm throwing you a bonus subject today because it is pertinent to the industry, and that is dealing with these safer at home or stay at home, quarantine, ISO, whatever it is you want to call it, business closure order. These orders that say you must stay at home if you are in certain categories of people, unless you are in an essential industry, and then you can go to work. and I'm going to use the Florida governor's order. Governor Ron DeSantis issued an order, and I'm going to walk you through that as a bonus issue to sort of highlight some of the legal issues that we see. Because I will tell you this, my friends, we are in not only is this a novel coronavirus, as you say it, but these are novel coronavirus legal issues. Our laws were not written to anticipate this sort of situation. And so many times I am asked, what is the legal basis for the government doing X? Fill in the blank, by the way. And we've struggled as a profession to explain some of these things. I've struggled personally to understand myself and to then explain to clients exactly what is the legal basis for a particular local government order here in my home county, Pinellas County, Florida, our governor's order, or even the national things that are going on. There are some issues. I hesitate to use a word so cliched as making it up as we go, but it does seem that from a legal perspective, that maybe there's not quite the legal authority there that you would expect a government to have in our kind of government. But those kind of debates are interesting and fun for a virtual happy hour if you do that sort of thing. I did my first one with Terry last week, so score that, but it doesn't really get you anywhere as a business, because the fact is the government are doing these things, and we need to be prepared to respond in the best way we can as employers to avoid and minimize those legal issues. We are all talking right now about trying to flatten the curve of the disease, and I fully support what we're trying to do and trying to flatten that curve. Hopefully today, I'm going to give you some tools to flatten another curve, which is I expect to be sometime in the next 2 or 3 months, is a dramatic increase in the number of lawsuits filed by employee advocates, employee lawyers about some of the things we're going to talk about today. I want to flatten that curve. So I hope you don't mind if I grab that flattening the curve phrase and use it here to talk about minimizing the threats to your business as opposed to in addition to your health. Now, what I'm not going to cover, I'm not going to cover SBA loans or the Paycheck Protection Program or anything having to do with taxes or other IRS issues. I am an employment and labor lawyer. I master my lane, but part of mastering my lane for 25 years has been to stay out of other people's lanes. These are issues for your accountant or your tax lawyer, maybe your business lawyer, but I don't do these sort of things. We don't do these things as a firm. We have some benefits lawyers that represent employers and advise employers on employee benefit programs, and they can advise you on some of the impacts of these, but we don't process the loans or help you with the submission of those applications and that process. So I will be staying away from those. So if there are those of you who have logged in today looking for that, no offense if you drop off right now and go find another webinar. All right, so let's jump into this bonus topic. So this is the executive order, the issue that came up with our executive order in Florida. I can illustrate by looking at the FAQ that the governor issued just a day after the executive order itself came out. Now, what the executive order says is that senior citizens and certain individuals with significant medical conditions had to stay home, but it used the words shall stay home. And first question, of course, was, well, what is a senior citizen? And the issue that immediately rose for us and still exists, it still hasn't been resolved, is what does senior mean? Under other parts of Florida law, senior is defined as 60 years old. If you look at consumer protection statutes, for example, then it means 60. But the governor's order also said we are to refer to the CDC guidance in interpreting his order, and that says 65. So what is it? Well, the reason I show this to you is because I want to illustrate and emphasize the importance of reading the exact word used by whatever executive order, whether it's a city or a county, whatever municipality you have, even an integrated government of a city and a county like Miami-Dade or even Jacksonville. When you look at those governments or state, you want to look at the exact words and do the best you can to understand. The individuals with significant medical conditions, Governor DeSantis listed out what you've probably seen in other orders, where it is individuals that have some heightened immunodeficient condition, where they are subject to getting infections, and you've heard them all so far. You've heard about asthma, diabetes, and others. I personally have asthma. So if you the way you read that order is that if I'm either a senior citizen or an individual with those conditions, I should stay home. Well, what does that mean? And this was a second question that came up and the reason for this FAQ. Well, what does that mean if the employee works in an essential industry and needs to go to work or can go to work? And so what does that mean? Well, the FAQ, and this question came right out of the FAQ, asked that question. The answer was yes, that the employees can leave their homes whenever they have to go provide an essential service or conduct essential activities. So if you have someone that needs to come in, work in the office, work in the call center, whatever the situation may be, and you're in an essential industry, which for the most part, I think technology firms, technology businesses do fit most definitions, but there's not a universal definition. Many, I've done this webinar, I think this is the 15th or 16th time now in the last 3 weeks, done it for different various kinds of industry groups and across the country. And I'll tell you, when you compare one to the other, it's not entirely consistent. Even when referring to the Homeland Security's definition of critical infrastructure, it still is not as entirely clear as it should be. So you need to check your local orders on that. But then the question came up, well, should employers require covered individuals to work? So should you actually require individuals that the senior citizen or someone with those conditions to report to work, to show up? Now, I'm not talking about telework, and we'll talk about that in a moment, but the showing up to work, leaving their home. Well, of course, option A is you could say, well, no, we're going to tell that person, no, we as a business, we've decided we're going to support the governor's executive order. And again, just using the Florida example, well, that's an easy one here in terms of minimizing or maximizing your liability protection, minimizing those safety issues. But what you are doing here is we'll go through this in detail, is you are by doing so triggering that paid sick leave under the FFCRA, and I'll show you how one of those reasons comes into play and it triggers. Option B is you say, well, come on to work. That's also permitted because, as I just showed you, that would be permitted. Again, cautionary note here, check your exact order and any guidance from it for your particular jurisdiction. But remember, the order also said that you still must take all measures to limit the risk by following the CDC guidelines. You may also want to consider some additional guidelines and some additional measures to further limit workplace exposure. OSHA just 4 days ago issued some new guidance on getting workplaces prepared, and CDC followed up with some additional guidance when it comes to what needs to be done. Industry best practices are also important. Now you notice option C doesn't exist. Option C might be requiring individuals to come to work. I don't recommend that. I think if an employee is covered by a local government order, because of those categories and does not want to come to work, then I think that you probably shouldn't make that employee come to work. So what are some legal issues that come up at telework or telecommuting? I want to go over these issues because I think this is important. I know that in the technology business, a lot of work can be done from home. We outside the technology industry, in fact, even in the legal services industry, my own, we are realizing that there is more and more work that we can be doing remotely. And I expect that when this situation, whatever our crisis abates, we will probably be doing a lot more. So work from home. So the technology business, you guys are in a great business. I think that you're going to see a probably increased demand for what it is you do by providing that infrastructure. So what are some of the best practices we've already seen and experienced with our clients? Well, clarity about which positions can do this is very important. Who can and can't work from home. Having a written policy for it. We've developed one ourselves. We now are allowing, I'll use our example, we're now using legal secretaries to work from home. That's not something we ever would have done before. We need to have some return to the workplace protocol whenever the time comes for someone to come back. You need to consider whether they've been exposed outside of work to someone that has either shown the coronavirus symptoms, COVID-19 related symptoms, or has been around someone that's been diagnosed actually with the disease. You need to talk about what other your company policies and procedures may come into play, and we'll talk about those, including how do you make sure that you're paying employees for all the time they are working for you. The wage and hour rules are not suspended here. I'll illustrate for you how a few rules seem to have been suspended, but the wage and hour rules about paying folks is not. Giving some direction on notification requirements, and if an employee does become symptomatic and can't even work from home, is important when you have to change that as well. You need to consider whether employees have got the tools and equipment they need. I think we went out and bought 1,000 laptops when this first hit. No exaggeration. It was really interesting. Number one, I think we got ahead of the curve in that we got that purchase order in fast. Scanners, printers, cell phones, all those are things that you need to consider, especially for those folks who maybe not have telecommuted before. Homeland Security, because I think every government agency has had input in this whole situation, and we're not going to, Homeland Security wasn't going to miss out. So of course, their reminder is to everyone, to employers alike, is to make sure that you use encrypted web connections. Make sure that your firewalls are updated. I'm now jumping into your business. You guys know these things way better than I do, but from a regulatory perspective, these are important things to do, because your legal liability as an employer could also increase if you are not taking measures to protect this information. When you have employees that are using connections that are not encrypted, then you have the possibility of losing confidential information that could cause you liability as an employer. Physical security, physical security, really, I'm not talking about the physical security of a person in their home. I'm talking about laptops and thumb drives and other things, and using data blockers on USB drives. Reimbursements, big question always comes up. Okay, fine. So now an employee is working from home and has to and needs a better internet connection. They needed to upgrade their internet service. And that's something you need to consider, is are you going to provide some increased expense reimbursement for that increase due to the teleworking? Now, a couple of things here to consider is that there are going to be some wage and hour implications to doing this, and we'll go over those. And then also, if you are, forget the fact that this is for being done for a pandemic, if you're allowing someone to work from home as an accommodation, then you actually have to provide that. So another kind of related question here that comes up out of, when folks consider this is, well, does workers' comp going to apply? My employees are covered at work, they're covered in the call center, they're covered in our offices, are they covered at home? Short answer is yes, they are. This is going to be a state-by-state change or a state-by-state variation, so make sure you understand that. You've had some employers, some clients go so far as to have employees designate their workspace. I'm not sure I'm fully on board with doing that quite yet, and certainly not advising these virtual site checks, but if you think there are going to be issues, it may be something to consider. I also expect that from the workers' comp front, I think you may see some flexibility in what traditional rules have always been when it comes to working at home, just like we're seeing some changing of traditional rules in other areas of the law, like unemployment insurance, which we'll talk about as well. Supervisors and remote management, if you find it hard to manage people face to face, it seems to me it's harder to manage them remotely. Although what I've learned from one of my clients is that some of their folks who are not so good at face-to-face management are actually doing better at virtual management. So interesting dynamic there. But setting up expectations and helping them, we've actually had some good internal training ourselves. Jumping back into the legal issues on wage and hour compliance, I'm going to draw a distinction for the folks that are teleworking between your exempt employees and your non-exempt employees. Your exempt employees are those employees. Terry, I'm not sure why the slideshow is changing the way it did, but I'm going to keep hitting back buttons. Pat, I think you're on, so if you can keep an eye on the technology for me, that would be helpful, because it bounced over to not controlling the screen.
Okay.
Thank you. So maintaining the wage and hour compliance, let's draw a distinction. Those exempt employees are those employees that are either your executive employees, who are your managers. It doesn't have to be an executive with a V or a C or director in their name or their job title, but it could just be a line level supervisor or foreman in the construction world, but supervisor in an office environment. Team lead is another term we might hear as well. Those are folks that you pay on a salary basis because they are not entitled to overtime, or they're not entitled to overtime compensation because they meet certain primary duties, and you've paid them on a minimum salary basis of $684 a work week, which equates to about $36,000 a year. Another area might be administrative, where someone is the head of an important function in your business, like your HR director would be a good example of someone who doesn't manage people directly, but manages an important process or operation or component of your business. Those exempt employees. And then, of course, we've got some exemptions for technology employees with the professional exemption for the computer and computer professionals, but those exemptions don't really translate to salary basis. They translate to different hourly compensation. So I'm talking right now about those folks that you pay on an exempt basis, paying on a salary basis. Generally speaking, you have to pay them for any work week in which they perform any work. So if you decide to start, and I'll talk about this later on about ways to save costs. If you send someone home and don't work for you in the middle of the week, you still got to pay them for the full week. Now, if exempt employees, and this is my point here on the right-hand corner, if they miss a day due to lack of work, then you've got to pay them for the full week. As opposed to those non-exempt employees, which is now the next slide. And the non-exempt employees are all those folks that don't fit those exemptions that you must pay on an hourly basis. And the baseline here, the base requirement is that you have to pay them for all the time they work, and an overtime premium of 1.5 times their regular rate for anything over 40. Again, some technology jobs, would just get paid on a straight hourly basis with no overtime. You change, but something to be aware of here is this one seems to be easy enough from a federal view because there's no other requirement. If a non-exempt employee isn't working, they don't get paid. Simple enough. Want to be wary of changes in scheduled hours or changes in rates of pay, because although federal law doesn't require any notices, some states do. So let's be mindful of that. The expense reimbursement, while we're still looking at the Fair Labor Standards Act, that's the wage and hour federal law. Just a few points here before we move on. Employers are generally not required to reimburse employees for business expenses. That may surprise you, but that is actually the law. There's not technically a law that says thou shalt reimburse employees for business-related expenses. Be mindful, though, that for those non-exempt employees, those hourly employees, you still can't do anything. You can't make any deductions from their pay that would take them below minimum wage. I suspect this is an area where some employers might get themselves in trouble by not giving employees reimbursement of increased expenses from working at home, and they work in such a way, or their expenses go up such that they end up running into an issue there. I think it's going to be lower level compensated jobs, but that could be an issue. What are some of the expenses? I think these are somewhat predictable, so I won't spend much time here, but home computers, printers, and other things. State specific, again, as I've emphasized earlier, please check your state law. Different states actually jump in where the Fair Labor Standards Act from a federal law doesn't occupy the space. States can jump in and fill in the blank, and they've done that with regard to expense reimbursement. When it comes to the non-exempt employees working from home, this is actually your biggest risk. We in Florida have a firm here called Morgan & Morgan. More about them later. They are a plaintiff's side law firm. They started as personal injury, but they've expanded into employment law, and they love lawsuits involving wage and hour laws. And there's a reason, and I'll explain that to you later as well, but they have a tremendous financial incentive to pursue those cases where they can recover far more money, sometimes many times over what they recover for their client. They get paid. It's not like a personal injury lawsuit where they pay 1% of the recovery. They get paid on top of their client's recovery by the way the statute works. So they love those cases. But what the big issue is here is that if you don't have a system set up to track all the time your employees, your non-exempt employees are working for you from home, then you run the risk that when we get through this thing and it's over, then you're going to have a problem with Morgan & Morgan filing lawsuits claiming that there was unpaid time. And that unpaid time would have taken the employees into overtime, and that creates a tremendous incentive. I think that's an area where you're going to see these lawsuits. So how do you do that? Well, time recording software is obviously something you can do, but don't ignore the old-fashioned employee attestation of time. Just simply have them send an email at the end of the week saying, hey, these are all the hours I worked for you and I didn't work anymore. That's enough. There's not really any particular form that's required, but I would have it done contemporaneously, maybe even daily, but no later than every week, and pick a day and before you do it. And you can also control their time. So if you wanted to say, look, I don't want you working more than 40 hours a week, and you need to send me an email when you hit 37, and they don't do it, well, the way the law works on that is you can discipline them for not following the rules. You still need to pay them for that particular work week in which they work that overtime, but you can discipline them and try and get them to not do it again. So predictive scheduling laws, that's a new term we employment lawyers are having to learn. Some jurisdictions around the country, and there's only a few, but some do require some advanced noticing of scheduling shifts and changing in those schedules. So check your local rules on that. If you're in California, I like to jokingly say we have put California into our international practice group. The rules in California are fundamentally different from federal rules and most other states' rules, except for a handful of those in the Northeast. They take a very different view of workplace legal issues. So if you're in California or a more, you can use the word liberal or progressive or employee friendly, whatever it is. But if you're in one of those states, check local for sure. So that's it on some of those telecommuting. What's kind of some guidance that OSHA, that the CDC issued last week with regard to those critical infrastructure workers. Again, I think likely is going to include most technology firms under most essential business orders, but check those. And what this new guidance says is that, well, generally speaking, asymptomatic employees, and now I'm jumping back into someone coming into the workplace. Or let me change this up a little bit for you, going to a client's work site, because I know it's important to many people on the call today, is that what if you, as the technology firm, you need to deploy someone in the field to be able to go serve your clients? All right, well, let's talk about those situations. Well, generally speaking, the CDC has come out with this new 48-hour rule that if your employee was exposed through a household or other non-work contact within 6 feet of someone that's either got symptoms or they're suspected of actually being of having COVID-19, then the employee's got to be symptom-free for 48 hours before you deploy that person to a client site or comes into your offices. That guidance is something that you should follow. Many clients have asked the question of, well, is the CDC guidance, is that law? Is that something that is that something that's required that we have to do? Do we have to follow that like we have to follow other laws? And the answer is it's not technically the law, but by being guidance from a healthcare focused federal agency, it sets up an expectation that you are going to do something to comply with its guidance. Maybe not everything, but something. And this 48-hour rule, I think, will come into play. How might you get in legal trouble? Well, if you know that there's something you should have done and you didn't do it, well, that's the foundation of a negligence claim, a personal injury case. And the plaintiffs' law firms we know are gearing up for these. If you expose someone and you did it in a negligent way, you might be exposed to having to pay something outside of just the workers' comp recovery. You might be able to, the employee might be able to get around that exclusivity defense if you're not following government guidance. In addition to that, OSHA itself doesn't have any specific standards that discusses what to do in a pandemic. But what it does have is what's called the general duty clause, in which OSHA has said, and this goes back to the original OSH Act itself, that you have got a general duty to have a workplace free of a recognized hazard. Well, I think right now, we don't know of any cases in which OSHA has issued citations yet, but we know OSHA has done inspections on this primarily in the healthcare industry, that employers are going to get in trouble. There will be citations written because the employer had knowledge of a specific threat of an exposure, not a general fear, but a specific threat, and did nothing, and someone got infected. I think that's going to be a case that could also be stated under OSHA. I did see a question come into the box, and I'm going to try and take that one right now. Let's see. So the question was, why are companies in the technology business essential during this pandemic? Great question. I think that the most answers have been, issued on that from all the various guidelines I've seen, is that it's the technology infrastructure that is important. And even whenever a business is determined not to be essential, there are, and this is again, folks, where you got to check your local orders, because when you look at those orders, sometimes you're allowed to do business as a non-essential business if you've got certain measures in place. So again, go back and check those local orders to see. Now back to the CDC guidance. Of course, if anyone is showing any kind of symptoms, that government says you should send them home immediately. And I think hopefully we can all agree with that, and then do cleaning and disinfecting. Now, just a quick word about your clients and what to do. If you are sending folks on site, some of the best advice that I've heard done or issued out in the technology business is, frankly, follow what your clients are telling you to do. But the caveat I would add to that is, if your client's requiring, N95 masks, then don't send your folks out there unless they have one. Granted, I know there's an issue about getting one, but at least the face coverings, with the cloth, which is also CDC guidance from the week before. But do not, and I will tell you this very carefully, because I know you've got to balance the business need, do not send any of your employees anywhere without you knowing what your client is doing. And it needs to at least meet the requirements of the CDC guidance, or don't send them. All right, so what else did the CDC guidance say? Some additional precautions for those returning to work. These are some things that they're recommending for the return to work folks that are coming back for that 48 hours. But I would tell you that I have seen companies in this industry and others that are doing all of these things with everyone, and that is pre-screening, taking temperature. Yes, you can actually take folks' temperature. This is an issue the EEOC, that's the Equal Employment Opportunity Commission, they jumped into this a few weeks ago and said, ordinarily, we wouldn't approve this sort of thing. We think this is an unlawful medical question underneath the Americans with Disabilities Act. We're not going to allow it. Well, now they say during a pandemic, you can. It's a good example of how laws that we had before this hit really didn't anticipate this sort of thing. And even when you look at the guidance from the EEOC from the H1N1 10 years ago, that was a different situation. The risk here certainly seems to be a lot more acute and intense. And so they are allowing more of these kinds of questions. And regular monitoring. So keep an eye on the employees, making sure that folks are covering their face. If you don't have a mask, social distancing, even at work, is important. And then disinfecting and cleaning workspaces as well. So, very interesting scenarios. All right, so someone asked the question of, is it advisable to have a customer sign an indemnification form before sending an employee to provide services to their site? Well, obviously from a lawyer perspective, I love those sorts of things. I don't know that you're going to get it, but what you could do is to have the employer tell you what they're doing. So what you could do is, if you're sending a field tech into work on servers at we'll use a restaurant. I mean, we've got some restaurants in Florida that are still doing business. They're just doing pickup and delivery only, but their servers went down. You send someone in there, not a bad idea to at least in advance. In fact, I would tell you, I think a minimum requirement is having that conversation ahead of time and documenting what you discussed with the client or the customer about what it is they're doing to keep folks safe, and then make sure that at a minimum it follows the CDC guidance. Can a doctor's return to work note state that it is COVID-19 so an employer knows to take precautions? So lots of issues come up with doctor's notes. We'll talk about some of those again in a few minutes on the paid sick leave as well. Doctor's notes I've seen so far don't necessarily refer to COVID-19 or even necessarily the symptoms, but the date of when it is right now raises the question of, should you have a conversation with the returning employee about what condition they're in and about whether or not they need to sit out work or take some additional precautions that they otherwise might do. Somebody asked a question. Are you saying that an employee can't sue their employer for being exposed to COVID-19 in the workplace? No, I'm not saying that at all. In fact, here's the question, and that really unpacks a lot of issues. And the question, first of all, is the question seems to assume that you know the exposure to COVID-19 happened in the workplace. And I will tell you that is not an easy thing to determine. That's an issue when it comes to whether or not you have to put such an exposure on your OSHA logs, whether you have to report it to OSHA, does it become a workers' comp injury? All those things come into play. And of course, in a personal injury lawsuit, that would come into play. When did the exposure occur? Was it in the workplace or did it happen somewhere else? And is the employer then responsible? Well, an employer is going to be responsible for doing something or not doing something if they know about a hazard. And if they don't know about the hazard, then no, there's not going to be that. I think maybe also the question was getting to what I referred to earlier about the workers' comp exclusivity. And that's just a basic rule of employment law that if you get hurt at work, you get the workers' comp benefit. Every state has what's called the exclusive remedy, which is you have to go through workers' comp to get any recovery from your employer. It's a no-fault system. The only determination is, did the injury, and here the exposure, did it occur in a work-related situation? And if so, then you're entitled to certain compensation under your state's benefits for workers' comp. The way around that plaintiffs' lawyers will use is that if they can show, if they can get around the standard in your state. In Florida, it's a virtual certainty. Here, to get around workers' comp, the employee has to prove that there was a virtual certainty that the injury, or here the exposure, would have resulted in someone's serious injury or death. And that's how you get around it. So great question though, but just sort of one of those basic things about employment law, that employees are supposed to go through the workers' comp system and get their compensation that way. Not to say folks don't try, and when I'm talking about workers' comp, I'm only talking about injuries or illnesses in the workplace. I'm not talking about discrimination, harassment, wage and hour. Those are all things you go straight against the employer from the employee side. So now the big law that comes in with these new paid leave requirements. The Families First Coronavirus Response Act is a new law that came into existence on President Trump signed it on March 18. It went into effect on April 1st. Before I jump too deep, don't forget there are other laws that still govern your business. You have your current policies that are also in place. Follow what your normal policies say to date. So if you have a policy on PTO and employees have accrued some paid PTO, then obviously you might let them use it under certain circumstances. Going forward, nothing says you can't change your policies, and we'll talk about what you may want to do there. Keep looking at state and local laws. New York and New Jersey, I think, are the two most recent ones that had jumped in and provided some additional paid leave requirements related specifically to the coronavirus crisis. The FMLA, that's the Family and Medical Leave Act. The old school or traditional FMLA provides employees, certain employees, not all, you have to work for the business for at least a year, and your employer must be covered in that they have 50 employees within a 75-mile radius. And if you have a serious health condition, then an employee would be entitled to 12 weeks of unpaid leave. That's unpaid, but it still may come into play in certain scenarios. And I had one with a client this morning where the illness was confirmed not to be COVID-19 related, but serious enough to where the employee is going to take the traditional FMLA leave. But at first, everyone thought the employee had COVID-19. Just turns out that he didn't. The ADA is the Americans with Disabilities Act. There are certain conditions related to COVID-19 infection that could be a disability. It's not quite as easy to analyze ADA issues because the ADA anticipates a disability as something more permanent than something like a virus that typically comes and goes. Yes, it may be fatal, but it doesn't last forever. So this law has a sunrise and a sunset. So the sunrise is April 1st. It is not retroactive. And then the sunset is December 31st of this year. I would urge my clients, and I would tell you folks now, don't count on it. I think that the paid leave in some kind, and the two kinds we'll go over today, I think some of each of those are here to stay. I think the first thing you're going to see is likely going to be some legislative movement to extend this deadline from December 31 of this year to December 31 of 2021. So I think my message to employers everywhere is get used to it. Who does it cover? This part surprised me when I first saw the news. I thought certainly that was a misprint. Certainly the news got it wrong, that Congress didn't intend to focus on small business on paid leave in the middle of this economic crisis. They were focusing on, they had to mean big business. Well, I was wrong. They exactly wanted to target small business. No reason to sit here and spend time on your webinar debating why, but that's what they did. And so it does apply, but it only applies to employers with less than 500 employees. And how do you do the counting? Well, let's start with all your full-time and all your part-time. Regardless of how long they've been employed, regardless of how long they've been working, they go in the count. Include anybody that's even on any kind of leave. If you had someone on FMLA, they count. Anybody you're employing jointly with a temporary placement agency or a PEO, they count. You don't count folks outside the US, and you don't count independent contractors, which I know in the technology industry, there's a bit of a line there that's should be subject of another webinar altogether about whether we are or not doing independent contractor the right way. There's a lot of times we aren't, but that's for another day. But don't count independent contractors, assuming they are truly independent contractors. You might get to or under the 500 or above the 500 if you want to avoid these obligations. If you have related companies and there is some centralized control over employment issues, some interrelation of operations and common management, you might be able to add them together to get over 500. Some FAQs here. Is there aggregation? There certainly could be some aggregation if there's common ownership, as I mentioned. Do you calculate the number of employees under the traditional FMLA? You do a 20-week period and look at the number of hours worked. Well, not here. So if you're covered under the traditional FMLA, it is completely irrelevant as to whether you're covered under this new law, the FFCRA. Question came in too on lots of webinars I've done in here, and I've saved really sort of the FAQs from the best of these. So what if an employer is over 500 now but falls below? Well, what's going to happen then? Well, it's the head count is determined the moment that somebody takes leave. That's when it's determined. Now, you may have heard that employers that have less than 50 employees are exempt. Well, you'd be correct that there is something to examine. There is something to look at if you have less than 50 employees, but it is incorrect to say that there is an automatic exemption. The Department of Labor, U.S. Department of Labor, has promulgated some regulations. They were emergency regulations that have been issued. You can find them at the Federal Register at that link, or frankly, just Google DOL FFCRA regulations. You'll find them. And you will see that they have developed this regulation that says this is what it takes for you to meet the small business exclusion, where you don't have to provide the paid sick leave or the extended FMLA leave. And this is a high burden to reach. You essentially have to show that the expenses from these leaves will cause you to not have enough revenue to cover expenses. And that's going to be difficult to do. There's not a form you fill out, there's not a document that you submit to the government, but you need to be ready to prove the entitlement to this exemption. And I would challenge you, I would urge you to be very careful in your attempt to claim this, because if you are wrong, there are lawsuits to be had and government investigations that could come your way. So I want you to be very careful about trying to claim that exemption. Do not do this. Do not try to claim this without getting good advice on whether or not your situation, your particular situation applies. So notices, if you're a covered employer, you do have to provide or post a notice. Here it is. Again, find it by just doing a quick Google search. It's got to be placed in a conspicuous location, but hey, if you don't have a traditional physical workplace, or if you do and everybody's working from home, then you've got to send it by email. You can also post it on your intranet or an external website, anything where employees would see it in a conspicuous location, physically or digitally. You've got to put up that notice. Even if you think you're entitled to that exemption of under 50, you've still got to put up that notice. This is the part that should be sponsored by Morgan & Morgan. That's our law firm in Florida that loves chasing these wage and hour lawsuits. They are very interested in what you are doing and not doing right now. I have spoken to my friends at Morgan & Morgan and other law firms that chase these cases. And what they do is they draft complaints and then they go find a client. I don't want you to be that client. I don't want you to be the one that they find to plug in and fill in the blanks for their lawsuits. I want you to follow the rules on this as best you can, because if you're wrong and they come after you, they get to recover their clients' unpaid wages. You double it because it liquidated damages, so it's essentially twice the back pay. But here's the kicker, is that they get their attorney's fees and costs. So you as a business not only have to pay the damages for being wrong, you've got to pay your attorney's fees, and insult to injury, you got to pay the other guy's attorney's fees. Nobody likes to do that. So we want to be careful. I suspect that when the 12 weeks of paid leave begins to run out for a lot of folks in May, you may see some lawsuits being filed. So of course the question is, well, what kind of lawsuits should we expect? Under traditional FMLA law and wage and hour law, there really are two kinds, but let's look more at the FMLA. There is a lawsuit that says you have you have interfered with my right to take FMLA leave and therefore violated the law. And so I'm going to sue you and either try and get reinstatement, which is rarely the case, or I just want a big check, and that's usually the attraction. Or retaliation, which is you had an employee take the leave and they claim that you somehow retaliated against them. I think one of the big lawsuits that may come out of this is this. If an employee takes either of these two kind of leaves, they are what's called job protected leave. That means that you cannot, as an employer, fire someone or take any adverse action against the employee for taking the leave. But it also means that you are supposed to reinstate them or bring them back at the end of the leave into a same or similar position. Here's the lawsuit. There are a lot of businesses out there that things are going to change in the next 12 weeks, 10 to 12 weeks. And during that time period, if you need to go ahead and terminate someone's position or do a layoff and they're on leave, it's going to be riskier to do. Now, I'm not telling you, don't get me wrong, I'm not saying you can't. If you're eliminating an entire group of employees and only some of them took these leaves, then that clearly you'll be able to show that you didn't make that decision based only upon those who took the leave, and you can still make that business decision and not get sued successfully. But if if you sit down in 2 weeks and say, well, we need to cut back and we're going to lay off everybody who took FMLA leave under the FFCRA, and that's how you make your decision, you're going to have a problem, because that'll also be a group lawsuit, a class or collective action by that group of folks that you targeted for taking the leave. So guidance here, don't target people who took the leave, but if you have to make a decision in which you didn't target them, but they just happen to be caught in a bigger net, then that's going to be a business decision that shouldn't get you in legal trouble. And then, as I said before, I illustrate it here further, it really is a matter of making sure, or really the incentives here are the lawyer's fees. So what are the two kinds of leave? I've hinted at them, now let's dive into the details. You have to require what's called, or provide what's called expanded FMLA or emergency FMLA leave. Now that leave, these 12 weeks are paid as opposed to the unpaid. And so some of the normal rules apply. So for example, their benefits are still covered, you still provide that. Any leave taken does count against their 12 weeks for other kind of FMLA, so they don't get 24 weeks, they get 12. The forms, don't use the traditional FMLA forms. There are, DOL says they're going to build new ones. They haven't done it yet. I'll show you at the end of the slides today how we've developed forms that you can use. My firm has, and we've got those as a resource for you. But this leave, this EFMLA, is only for one kind of situation, and that's this. The employee who needs the time off as a minor child, that means under 18, and the school or daycare closes, or their regular child care provider like a nanny is unavailable because of this crisis. And as a result, the employee can't show up for work physically or telework. And there's a big key, because if the employee can do their job at teleworking, they're not entitled to the leave. It is unpaid for the first 2 weeks, but I'll show you how you can link these two, or employees can link these two together to get all 12 weeks paid, including those first 2 weeks. The pay through the FMLA is at 2/3 of an employee's regular rate, but there is a daily cap of 200. So don't get too caught up in how you figure out the math on regular rate of pay. If they're going to go over 200, stop there. Now, I mentioned earlier that you still have to consider what your current policies are on leave. And what I want you to look at is this. You can't require employees to use accrued PTO for these first 2 weeks, but you can allow them to do that. It's got to be by agreement with you and your employee. The sick leave. So the sick leave is next. I wanted to draw a bit of a contrast here because with the sick leave, the EFMLA, employees have to work for you for 30 days, but for the sick leave, it's day of hire, no waiting period at all. So now this is the second type of leave. The second type of leave, there are 6 reasons for an employee to be able to take the FFCRA paid sick leave. And if you're paying close attention, look at this list, and I will show you in a moment, one of these has nothing to do with anyone being sick. But that's how it happens whenever you try to make a law under time pressure. You know, they say making laws is like making sausage. You don't really want to see the process. Well, now let's make sausage and let's do it under a shot clock with a global pandemic emergency. And that's what you end up with, a bit of a confusing component here, which is that, yes, reason number 5, I'll highlight for you now, is that nobody is sick, yet you can still take paid sick leave. And that has caused mass confusion in the workplace because of those notice postings that employers have had to put up. So we'll go through each of these. What are the reasons how an employee can claim and you as the employer must provide paid sick leave? Well, the first one is an order just like Governor DeSantis issued. If there is a state or local quarantine or isolated order, check the box here in Florida. We've got one. You probably have one where you are. They are almost universal nationally right now. Very ubiquitous they are. And someone has been ordered to stay home and they don't want to come to work. And as I said before, not a good idea to make them, although we can talk about various fact patterns in which you might encourage them in different ways. But if they've got it, then they can get this sick leave. Now, this is not the 12 weeks, by the way. I'll show you on the next slide that they only get 80 hours. Up to 80 hours. It's 2 weeks of regular work up to 80 hours. So this is not the full 12 weeks, but they do get the sick leave. Second reason is that they are self-quarantining because a health care provider said so. So it's really not a self-quarantine as much as it is them just following their doctor's advice to stay home. Third, and that's very individual specific, unlike reason number 1, which deals with a class or group of people, number 2 is an individual. Number 3 is also the individual, and that is your employee having symptoms. And the key word here is the word and seeking a medical diagnosis. The regulations made this point very, very clear. An employee doesn't get this paid leave just by saying, well, I feel like I've got a sore throat and I might have COVID-19, so I'm just going to stay home until I feel better. No, that's not enough. They also have to be actively seeking a medical diagnosis. And yes, you can require documentation or evidence that they're doing that. It doesn't even have to be physical. It could be telehealth. It could be calling into the health department, but they've got to be taking some action. The fourth reason has caused some interesting fact patterns, and I'll share one with you in a moment that seems to have come up often, which is caring for an individual subject to quarantine or isolation related to COVID-19. So in other words, your employee has to stay home to care for someone who fits under 1 and 2. But that individual is not anybody. It's not a neighbor. It's not a family friend. It's got to be someone who is in the home with you, with the employee, and someone that depends upon your employee for their care. And I'll illustrate that for you. Reason number 5 is the one I said earlier. I'll show you how these two link together. This is how your employee can grab reason number 5 and say, well, I need to stay home. I'm not sick. My son or daughter's not sick. This has nothing to do with COVID-19, but my child's school is closed, their daycare is closed, or their nanny is not available. Then they get the extra 2 weeks. So that allows them to go with a full 12 weeks of pay. Now, the regulation here does modify the pay, and if they are using reason number 5, the pay is only at 2/3. It is not at full pay, which is what the other 4 reasons would be. I can't tell you what reason number 6 is. We have not gotten an explanation from DOL yet. wait and see if they expand the reasons. Here's the scenario. So an employee says, hey, I need to take this paid sick leave and not show up to work. There's no telework available in this scenario for my illustration. Let's say it's a call center operation, something where there's got to be a physical presence and it's an essential business. But his wife has asthma, and that's a covered condition under the government, local, or the state or local government order. And the doctor also said, hey, here's a note. Now, the note itself didn't, and I am thinking of one in particular, the note itself didn't say anything about COVID-19, but it did talk about being immunodeficient, and it was issued on April 3rd. Oh, that was enough for me. Okay, fine. So we can conclude that she fits reason 1 and she fits reason 2. And your employee says, but I'm afraid of coming to work because if I come to work and I go to work and I may get exposed to other people because my employer is not doing a good job in the call center of following the CDC guidance or guidelines. So when you look at the paid sick leave, look back at this scenario, let's change it just a touch and say that it wasn't a call center. Let's say that you're deploying employees into customers and the employee believes that customers aren't following the guidance well. All right, so fine. So there's this general concern, but nothing specific. Well, I didn't do this. I didn't hide the slide answers here because I didn't want to trouble you with that problem, but the answer is no. And the key here is that unless his wife depends, and the regulations are very clear on this, unless his wife depends on him for her care, then neither the order nor the doctor's note is going to be enough. And the general fear that he might get infected, that's also not enough. Now, this is an area where policymakers are arguing and fussing about this and whether or not it should be different. And I get it. I understand there's an argument that maybe this should have been broader, but it's not. And let's deal with what the law is as opposed to what the law should be. And here you don't do it. So how much leave would the employee get? Full-time employees get up to 80 hours. Part-time employees, you do it on a 2-week average. Variable employees, you look at variable schedules, you can look back 6 months, add it all together, do the math and come up with what the pay is going to be. There is, like the Family and Medical Leave Act, there is, excuse me, there is a cap. It's $511 per day, $5,100 in the aggregate. So let's not go too far with our math if they're going to hit that number. Final bullet point there emphasizes what I said to you earlier, that if they use reason number 5, then it's at 2/3 of their rate for those first 2 weeks, as opposed to being the full pay. Once an employee does take this leave, stay in touch with him or her and require him or her to stay in touch with you, because reasons do change, and we're starting to see a lot of fact patterns emerge there. So carryover and payout, these questions come up quite a bit. Does the paid leave, does it carry over? The law is very clear and says, no, there's no carryover. You can't bank this. And if you end up having to lay someone off, they don't get paid out the balance of the leave if you've done the termination the right way. Pre-existing policies and other leave, as I said earlier, we want to make sure that we consider those, but you cannot require these 2 leaves. The point to be made here, they are on top of what you already provide. They are not allowed. You cannot require employees to burn their current policies before they get these. They get these and they get to keep their other policy or their other benefits you provided. Just a quick check here. This chart we updated in January and it's already outdated, but do check your state and local leave laws to see what might happen. This slide you can use later. This is the checklist on how employees may want to or may need to link those 2 leaves together using that 5th reason. A few more FAQs. So will the employees be required, or will you as an employer be required to acquire a health certificate from employees? Well, there are some documentation, and I'll go on to the next slide about what you can ask for, and you certainly should, but I would urge you not to be, I guess to use the word, draconian in your requirement of documentation. The whole idea here is to provide this leave if employees give you a reasonable basis for their entitlement to it, and especially in the area of doctor's notes, in which it's not easy to get a doctor's note within a day or 2 or 3 even. I've even got some clients that are pushing it out into the 2nd or 3rd week. You just have to be as flexible as you can, and sometimes I don't know that you want to always take your employee's word for it. If you have reason to believe that their request for the leave may not be sufficient. This has happened too, where employees have gone out on either one of these two kinds of leaves, and mainly the sick leave. And we've seen Facebook postings of big parties where there's no social distancing going on. So sometimes employees may show you themselves that they didn't qualify for the leave. What tracking tools would be necessary? The regs do require you to keep documentation showing when you gave the leave, how much you gave, and you're going to need to be able to track that to make sure that you understand what your obligations are and for those tax benefits. You know, again, that's an area that I'm not going to jump into because I don't handle that sort of thing, but you're going to need to be able to document to the IRS and to your accountant the exact amount of money that you spent for the exact amount of leave, and they're going to want to know who took the leave and when. So what documents must an employee provide? The regs require this information: the date of the leave that they need, the qualifying reason, oral or written statements of being unable to work. You know, again, let's not be too over the top in documentation here. If you've got a representation from your employee and it makes sense, you know the employee's always had asthma, don't ask for a doctor's note on their asthma. If they are staying at home because a healthcare provider did tell them to self-quarantine or isolate, I would encourage a note in that circumstance because they're trying to check the box on the basic qualifying reason if you don't otherwise have reason to know it. This is a key fact I want to emphasize for you here. This is in a part of the regulation that has not gotten much attention. So maybe on the leave issue today, if I gave you value, this might be it. Because as an employer, you still need to manage these leaves. You absolutely want everyone who qualifies to take the leave. But there is a requirement here that is something that has not gotten much attention, and that is that second bullet point, that if someone is taking leave to stay home and care for their child, they have to show that no other suitable person is available to care for their minor child. So that comes up often now. I think I've got a question on this every day for a while, is, well, what about if there is a spouse at home or an adult aged child at home who can care for the minor child so that the employee can work? Well, under that circumstance, this part of the regulation would require the employee to say, no, that person's not suitable for various reasons. Now, you can also, and this also requires, I think, coordination among spouses. And several clients have done just that, where the wife is going to work Monday, Wednesday, and Friday. The husband works Tuesday, Thursday, and they alternate on who's caring for the kids. Now, that's all assuming that they can't telework or caring for the children, keep them from teleworking. And I tell you what, that's the big thing on Facebook, right? Is how do you telework and care for your children at the same time? So I'll leave you to your own to go look through that. What documents overall do you need? You need to keep everything you need, and your accountant tells you as well about the tax credits. All right, so the last big bucket of things we'll cover in the last 23 minutes, and I will finish on time, folks, but I want to see if you got any questions on the leave. It looks like the questions that were asked on leave I dealt with on the FAQ. So let's jump in now to, this is the part of the presentation that really is kind of the roughest part. This is the one where, all right, you've done what you can do by way of scaling back. You've done what you can do by way of managing the workforce through teleworking, but now you're gonna have to make some cuts. Now you're gonna actually have to let some people go, do some terminations, or that word furlough, which I'll talk about in a moment. And you know, that's a tough area to talk about. This is the part that really pains me the most. And I know we have a healthcare crisis, but we also have an economic crisis when you have millions of people, I think as many as 10% of the workforce in a 3-week period file unemployment claims. I mean, that carries a real cost to it. So this part is a sad part for me. It's rough, it's tough to go through, but I want to make sure you have the legal tools you need if you need to make these decisions and do them in a way that helps your business survive. Because for me, I look at this whole thing as not only a healthcare issue, but it's also a business survival issue. And we can balance the two. We don't have to pick one or the other. They can be balanced. So this is maybe part of what you have to do. So what is a furlough? A furlough is simply a temporary unpaid time off or leave of absence, if you want to call it that. It doesn't really technically have a legal meaning, but if you read the paper or read the news, not paper, of course, in this world, digital, but if you read the news, you hear that term all the time. What it essentially means is you're sending employees, either exempt or non-exempt, you're sending them home without pay for a temporary amount of time, but you really hope they're going to come back. Not guaranteeing they're going to come back, and that's a key thing here. You should not be making any guarantees that anyone's going to come back. Anyone making a guarantee right now when it comes to business or legal issues is, I think that's fool's gold. I think you're chasing something. I think about 3 weeks ago now, I stopped using the phrase, well, there's no way the government's going to do blank, because when I would say those things, within hours, if not days, there would be yet another thing that would fill that blank and surprise me. So I think that giving anybody a promise in the future would be, fool's gold. It also would put you in a situation of having to follow what you said. It would create a contract right for the employees, and you don't want to have that if you need the flexibility to make some business decisions. But if you are going to do temporary layoffs, you do need to cover these issues. Is it going to be mandatory, or are you going to take volunteers? Because you need to cut payroll by a certain head count or a certain dollar figure. How long are you going to target? Hard to say. Looks like, I think I saw an update a few moments ago that President Trump is forming a task force to start working about reopening the economy. Maybe we'll start to get some better idea from a government perspective as to when we might see some of these orders lifted about essential and non-essential businesses and what they can and can't do. Do you want to stagger them out or make them uniform for everyone? Do you want to take different approaches for different types of employees? You certainly can and should consider all of those. Some of the benefits of doing a furlough, obviously the optics and the messaging are better than just doing mass layoffs. You aren't triggering certain things like severance benefits and terminal payouts from papers and requirements from different states and local governments. But cautionary note here, the unemployment insurance compensation is an area that we employment lawyers don't really deal with that often. We haven't really touched it much in the last 10 years. It hasn't been that big of a legal issue, but now it is, because the CARES Act, which came in after the FFCRA, which does provide up to $600 a week for unemployment claims on top of whatever the employees are getting from the state. The question is, are the states relaxing the requirements of a waiting period or any amount of compensation? And the answer to that seems to be yes. So you need to check your state unemployment and see what that looks like. What are the disadvantages of a furlough? Well, some of the big issues that come into play is, what are the CARES Act implications on unemployment? Are they going to get it or are they not going to get it? You might still be triggering with a furlough your state's WARN Act. A WARN Act is simply a requirement under federal law that if you're an employer with a certain number of employees, and it's just typically bigger businesses with at least 100 employees, then you're going to have given them 60-day notice before you do a layoff. And that might include a furlough. And some states have put in other notice requirements as well. Do you have final pay requirements that get triggered? So for example, California is one of those states where you have to give if you let someone go or furlough them, you may have to give them a check the day up. That may not be something that you're ready to do. So you need to be ready to do that before you make that decision. Some other issues that come into play about how and when or why to require employees to use their sick leave or PTO as opposed to sending them home. The wage and hour issues I really touched upon earlier and hinted at, which is that, if you are sending someone home on a true furlough, don't let them work at all, because if they do, then you've got to pay them for the time they work. Now, one strategy that you may want to use here, and I've seen this used really quite a bit, is sending home an exempt employee you pay on a salary basis, but convert that person to hourly if you need them to do something. Maybe you don't need them 50, 60 hours a week. Maybe you need them 10 or 15 or 20. Nothing says you can't change that person over to hourly and cap their hours at that number. When you do that, you're losing the exemption because you're no longer paying the minimum salary basis for the work week, but you are giving yourself some more financial flexibility. So for the exempt employees, and that's, actually, I think I just jumped ahead of myself and talked about how you can convert people over to hourly if they're exempt employees as another option for how to deal with folks on a furlough. The salary basis minimum requirement there, you can look at this slide for reference later. and then check your state, because some states have a higher minimum, like of course California, that went into effect on January 1 of this year. Non-exempt employees, if you sent them home on a furlough and they're not working, don't pay them, but you can require them to substitute paid PTO, vacation, and sick leave for missed work. Big question comes up here, and this is going to go back. I'm going to link you all back to, this is probably one of the hottest issues we've dealt with, is do I have to provide employees the paid sick leave or the EFMLA, the paid family medical leave if they're furloughed? The answer is no, and here's why. The Department of Labor has said this act, the FFCRA, was passed to provide paid leave to someone who cannot work or telework a job for a qualifying reason when work is available. But if work is not available because the employee has been furloughed or the business has been shut down, whatever reason, if there's no work available, those leaves are not triggered. So big issue that came into play that the government had to provide us an answer for. If you're changing hours, this is something I hinted at earlier as well when talking about the telecommuting and maybe reducing hours. Some states, and here they are, require some advance notice. I'm not at all surprised by California, Connecticut, and New York, but South Carolina has always surprised me on that one. Who knew? That's evidence, again, of why you always need to check your state law. And when you change pay, that may come into play as well. So what about states requiring payout of PTO? Some states do. And they place a limit on furloughs and then that say you can temporarily lay someone off. Now, what about benefits? Another hot issue and question that comes in is, how do you handle employee benefits? Well, employee benefits are required, you know, they typically do continue when an employee is out on furlough, but what do you do whenever they are out for more than 30 days? Most benefit plans, most healthcare plans say that if an employee is not working for 30 days or more, they have to come off the benefits. Well, that's an area where you've seen not necessarily legislative, but you've seen policy changes. Many carriers have extended that out to 60 or 90 days because of the crisis that's going on. So, you know, big issue there to consider is, you know, the employee's benefits. You don't want them losing benefits. So a lot of clients have had to reach out to the carriers and have that conversation. The big major ones have already announced changes. So but I would still encourage you to track your individual plan to make sure that you've got that available for the employees. And then some states do require payout of paid time off before you can furlough someone. So if they've banked the pay, then these states listed here require that you have to go ahead and pay it out. California being the most aggressive, and then followed by others, some that say, well, if the furlough is likely to result in a termination, then we want you to go ahead and pay out the money, the paid time off now. So when you do a furlough, it doesn't mean that you're necessarily saving cash immediately, but you may be saving more, you may be saving some cash, but not all. And what if an employee doesn't want their PTO paid out? Unless you're in one of those states, then you know, you may be able to, and again, let's check your individual state, your jurisdiction, but if an employee gets furloughed and they are able to claim unemployment, and they want to keep their PTO bank because you do expect them to come back, that might be a win-win for everybody. I have had clients work through this one, and that is the speaking of unemployment, just on a side note, the unemployment benefit has been so large that it has caused some layoffs. It has caused some employees to come to their employer and say, I can make more money on unemployment, so I'm going to do that, and I'll see you in the fall. Don't know if you faced that. That certainly, I think, would raise some questions about the employee's fit for the business, but I'll let you make that decision. So other things you could do besides a furlough, you could reduce work weeks. There are some advantages to doing that for non-exempt employees. If you reduce a work week for a non-exempt employee and you're not, you know, they're not working, you don't have to pay them. Fairly easy. For your exempt employees, if you want to reduce their work week and reduce their pay, that's fine as long as you are being mindful of what the salary basis minimum is. And under federal law, it's that 684 figure. As long as they're making that minimum and their primary duties are the same, you can cut back. What I've seen here is I've seen a lot of percent reductions where everybody in the office is taking a 20% pay cut. And that includes exempt on the hourly rate, and it includes the non-exempt on the hourly basis and exempt on the basis of the work, on the salary basis for the work week, that works too. And we already covered the paid leaves from above. The new unemployment benefits, I think I spoke about that earlier. The unemployment assistance at $600 lasts 16 weeks. That's quite a bit. That's going to last a while. So that may end up resulting in some additional compensation for employees if they fit on the leave, if the waiting week is waived, which is what we've seen from federal, but we've got to see it implemented in the states. If you reduce employees' hours, are they eligible for unemployment benefits? In Florida, the answer is probably not, but the rule may be changed imminently. So be mindful of what your state, what your jurisdiction is. And there's this concept in unemployment called partially unemployed. And you need to find out. So this one really is, just as I've said earlier, some things I can give on a general webinar basis across the nation, but this is one where you really got to check your specific state with that. If you provide active employee benefits, such as keeping them on the payroll, does that impact their unemployment, such as keeping them on the payroll and keeping them on your health care plan? That actually doesn't impact their unemployment. So feel free to continue doing that. It's just if you pay anyone during a furlough period, make sure that you're not harming their unemployment if that's the direction that they're going to go. Starting to see more and more of these sort of work share programs where employers, are sharing employees back and forth. That raises a lot of different issues that probably would take a whole different, that's probably more of a client specific thing to go through, but these are some of the issues that you may see. Is you may start seeing industry shared employees from employer to employer. I've seen that happen already in the construction industry, which is where I spend a lot of my time. They have a lot of employees that are being shared because most trades in the construction industry have been deemed to be essential. So can I supplement employee wages while they're unemployment? Well, some, you probably could do some here, check your state to find out. But let me ask a different question. So if you can't harm, if you cannot harm an employee's, or if you won't harm an employee's unemployment comp and you want to provide them extra wages and they're not working for you, then I would tell you this, and this is a creative thing some employers have done, is you are not actually following the minimum wage and the overtime laws at that point, because you don't have to, because that law that requires the minimum wage and the overtime and the salary basis, all those laws, that's talking about compensable time when employees are actually working. But some employers have said, go home, we're gonna, not pay you, but I want to give you $100 a week for groceries, but it's not for work. Well, that's a payment you can make as long as it doesn't impact their unemployment, that you would be able to do, and the wage and hour laws don't come into play. The WARN Act, I mentioned earlier, if it's federal, there are also some mini WARN Acts and various state requirements, so check those. Voluntary separation programs, some employers have just said, don't expect that you're going to be coming back. We need to lose 10 people, but we'll take volunteers. And if you volunteer, then we're going to give you a severance agreement that will give you pay for 1 week of service for every year you worked for us. Now, that's a rule of thumb, by the way. You're not going to find that amount in any book anywhere, but that's typically a rule of thumb. So you certainly might be considering something like that. If you, as an employer, ever give any employee money as part of a separation program, you must always get an agreement in return. Now, there's no law that says you have to, but I'm just telling you, practically speaking, as a lawyer that does this, you don't ever want to give a departing employee money without getting an agreement in return that allows for a clean break in the relationship. So nobody's suing anybody for anything, and here's your severance pay. There are some legal requirements depending upon whether you're doing it with one or more people as a group, or if you're going to be doing it with someone that is over 40, because then there's additional disclosures and language that you would have to provide in those agreements. COBRA, that's the law that allows for health plan continuation. You should be okay in this area. Most employers seem to be finding that they're okay as long as they have had the conversation with the health carrier, the health plan carrier, about the furlough period and continuing coverage without triggering COBRA, and then the employee having to shoulder that financial burden. Can you eliminate employer contributions to retirement plans? Yes, you can. Can employees get the distribution under the CARES Act? You may be aware about the new distribution, which allows up to 100,000, not tax-free, but penalty-free from retirement plans. So we got about 6-7 more minutes here. Final wrap up here. If you are going to do whatever you decide to do on these cost-saving measures, whether it's furloughs or anything else, make sure you're communicating well with employees, specifically on furloughs, making sure they cease all work, return property, PTO, payout usage, consider that issue and the benefits, and those things. Now, some questions that come up and we've seen from time to time ask about those forms and policies. I mentioned it earlier. I'm going to wrap up now. It's just a couple of minutes here and we'll finish on time, but just to give you an overview of what resources we provide, if you go to Olgetree.com, our firm's page, you'll find our COVID-19 Resource Center. Follow that link, you'll see what resources we provide outside the paywall, which are these. We've got a detailed FAQ. It's really quite good, and we keep it updated daily. That goes into the FFCRA, a lot of the issues I discussed today. If you happen to work for someone who's already a client, we have a daily update email and can provide that. We do have some resources that are behind that do require you to be a client of the firm. We've done a flat rate fee for these as opposed to charging by the hour for these templates. And these are everything you need today. I mean, really, we've looked at every issue and I think it's very helpful, especially at the bottom, the FFCRA compliance documents. If you want to know what they are, if you go to that COVID-19 Resource Center, we do have explanations. This is the explanation for the FFCRA policy for employers that we've provided. And then this is a list of forms that we provided. So if you're used to managing the FMLA and you don't want to create your own forms, this is a pretty economical way to do it. How we work with clients, of course, we're lawyers, so we bill by the hour. That's always standard and typical and expected. We also are industry leaders, I think, in legal services when it comes to flat fee arrangements like handbooks, training, audits, these things, and hotline services where we provide a certain amount of advice and counseling for employment and labor law issues. So with that, I'm going to leave my contact info up on the screen, bounce over. Terry, I think we took care of questions as we went.
You may have a few new ones, or have you gotten to all of them?
I think I have, unless there's something going on with technology. I think I've addressed all these, but help me out here. Do you see any I missed?
You know, there's a lot of great information here. I know it's a lot of information to consume at once. Obviously, a very complicated situation that a lot of businesses are going through. Judging by the fact that almost everyone that joined stayed on, obviously you got a lot out of it. Please do ask any questions you've got while we've got Phil on the line. This is the one and only time you'll ever be able to talk to him for free. Even having a beer with Phil costs about $500. So this is a once in a lifetime opportunity to get free legal advice. I'm just kidding. In all seriousness, though, this is a time where, you know, we got to take precautionary measures to make sure things don't get worse. You know, the reality is we think it's rough staying at home, but it could be a lot worse, including having 25 lawsuits placed on your desk on May 4th if you return to work at that day. So what we got to do is to be practical, pragmatic, take precautions, execute properly, take due diligence, and the things that we've learned today, and have them guide our practices over the coming weeks. So don't have any more questions coming in. So Phil, let me thank you. Thank you for coming. I know you're busy. I know you're really busy right now. It means a lot to me, and I know everyone on the call to have gotten the advice and counsel that you've given. We appreciate you. And appreciate the work you do helping business owners defend themselves against frivolous or non-frivolous lawsuits, I guess, just depending on the business community. We appreciate you. Any parting thoughts you'd like to leave our listeners with?
Yeah, no, I mean, it's really, I think what I said at one point, I made the comment of there's a balance here, and businesses should be thinking about that balance. You know, let's make sure first and foremost, take care of everybody's safety and health. That is by far the most important thing. But business survival matters because, you know, this is not just about the owners or executives making a buck and, you know, buying their big retirement boat. It's all about employment. It's all about jobs. And, you know, government doesn't provide jobs, businesses provide jobs. And so my mission has always been to help businesses follow the law, but also stay in business. And now it's more important than ever. We need business to survive. So let's do these things the right way. Let's do these things with balance, and make sure we all come out on the other side of this and be ready to thrive instead of just trying to survive through it. So that's all I have to say, Terry. Thank you so much, my friend.
Thank you, sir. I appreciate it. Thank you all for listening. We'll go ahead and have this available for download. If you go back to your main invitation, you'll be able to watch it on demand after this. Thank you again, Phil. And thank you to everyone that's joined. Have a wonderful day. Stay safe. And God bless you all.